chance to hear it, so let her tell it. People on the streets say Sabrina speaks. Tune into the show, she will let you know. Tell all your friends and family. Real talk is no joke. You get the news straight up from grassroots and concerns. You can hear it, some people gone. So tell all your friends to tune in to
Good evening, Cayman. I'm Sabrina Turner, and welcome to Sabrina Speaks, your daily dose of clarity, truth, and community insights. Every weekday from 5 to 6:30 p.m., we're tackling the issues that affect you, from national headlines to grassroots concerns. Whether you're in traffic or winding down your day, this is your chance to hear it straight and speak your truth. So buckle up, Cayman. We're not holding back.
This is the show. We gotta let you know. Now we got to go.
And now here's Sabrina.
Well, good evening, everyone, and welcome to one and all, near and far. And I'm quite sure we can share into that narrative here from the beautiful Cayman Islands on this Monday afternoon. We're cool too. Very cool. Yes, it's good to be back with each and every one of you as we look forward into this new week, thank God, and a new month. Hello, February. Can you imagine? It is February already. I am Sabrina, and welcome to another episode of Sabrina Speaks, Voices of the Islands, Conversations for the World, the podcast where voices rise, stories unfold, and inspiration takes center stage. It is so good to be back with you on this cool Monday. I love the weather. I just love it. But today's episode is called Good Governance 101. What Caymanians deserve to know. And I hope that you will, again, join in this discussion once we set the context. The phone lines will be open to get your feedback on it. And I chose that title very intentionally because if you read the news and you saw this week, we witnessed a real-time example of good governance and what good governance look like when the system is working the way it should. And you may have seen the headlines in the Caymanian Compass about the Grand Court reinstating a lawyer who had been removed from the legal aid list. There were other media sources as well that covered this story. And now this show isn't about personalities, right? No, this is not about the personalities involved at all. It's about, and it's definitely not about taking sides. It will be about understanding why these rulings matter for every single person living in these islands. And we'll also go into what happened this week. Pretty much would play out like a textbook case study in governance, oversight, and accountability. Because the court found that the director of the legal aid went beyond the authority given under the law when they removed the attorney. And whether you agree with the lawyer or not, the bigger story is, one, Cayman's checks and balances definitely kicked in this case. And this is how the system is supposed to work. When a decision by a public authority goes beyond that of laws, then the court has the power and the duty to step in to correct it. Not to embarrass anyone, not to create any scandal, but to protect fairness, due process, and the rule of law. And in a small island like ours, where decisions can feel personal, and where definitely power can be concentrated in just a few hands, those safeguards are not optional. They are essential. So in this episode of Sabrina Speaks, I'd like us to take a break, just breaking it all down. And you're invited to join in on the conversation. We can talk about what is good governance, How do checks and balances actually function here in the Cayman Islands? And what does the accountability look like in a community where everyone knows everyone? We know how that goes. And most importantly, how each and every one of us as Caymanians use civic power to influence policy. That is a reality, and it's playing out daily here. And demand transparency, when you look at that, and the strengthening of the systems that protect every one of us. And you know what? Because good governance isn't just something that government does, it's something that we all participate in. So today, we're going to talk about that and what Caymanians truly deserve to know. Now, the content that you're about to hear, including any discussions or opinions from myself, guests, and our participants, is intended solely for general, informational, and entertainment purposes. It's not a substitute for professional legal, medical, or financial advice. So I encourage you to consult with a qualified professional for your specific concerns. Bridge Media Limited and all its affiliates disclaims all liability for any decisions or actions taken in reliance on the information presented. 345-936-8255 is the number to call and be a part of this discussion. And of course, whatever social media you're tuning in, you can always put your comments up there as long as they're fair, balanced, respectful. You're more than welcome to weigh in on this. Yes. So the number for WhatsApp, or you can call in and join in live, is 345-936-8255. I see you all coming in there. I know. I see you all. Yes. Let's go right into it. Oh my gosh, look at those temps. Look at that. Look at that. The temperature right now is a cool 66, and we are having fresh to strong northerly winds, and rough seas are expected to continue across the Cayman area for the next 24 hours as a strong high pressure system continues to dominate our region. Now, the Marine Watch has now been downgraded to a small craft alert, and which is valid through Thursday evening. The sun will set at 6:17 this evening, and it will rise tomorrow at 7 o'clock in the morning. Now, the outlook, as you can see, is called for moderate to fresh northeast winds and seas today into Wednesday as this pressure gradient weakens over the Northwest Caribbean. And guess what? A small craft alert, as I said, even though it's been downgraded, is still into effect into Tuesday, downgrading to an advisory on Wednesday. Thank you to all of the teams over there at the Cayman Islands National Weather Service for a job well done. And definitely, I've been out and about this weekend. I ventured out. It's like discovery. And I watched the waves. I drove from town along South Sound. I went to West Bay and all of that. So it was good to watch that. The Department of Environment, DEH, NRA are going to have a lot of work on their hands. Cleaning it up once these waves subside with all the debris and stuff. They've been doing a pretty good job, I must say, to maintain it. But from what forecasters are seeing, we could be in for another cold front coming in the later part of the week, coming down the U.S. Not to say it's going to be this strong, but yeah, it's the season. It's that time of the year. But we did. Remember Friday, I said it? We could be experiencing history in the making. Yes, and we did. This is the first time I think Florida got temperatures within 35 degrees. And even here in the Cayman Islands, it feels like when you go to Miami this time of the year with their seasonal temps, it's really, really cool. But without further ado, I'll leave the headlines and round up for a little bit. Let's get straight into things. Good evening, caller. You're early to class. And shout outs to all of you who are actually coming in as well.
Well,
we're off to the races today.
Well, Sabrina, I have to start with an apology to put you under such pressure when you are still talking about the weather and the weekend and just relaxing us as your audience. Now here I am with a call straight away.
You're poor. You leave it to you. You just go straight off to it. I'm not surprised that this is intriguing to you because of the very nature of it. And you know what? When it comes to legal aid and the checks and balance, and it's like what I said at the intro, it's almost a case book perfect style of governance. And it just lays it out. No matter what side you look at it for, the process was followed through, a ruling was made, and guess what? It can't even be appealed. But let me hear where you're taking it from. Welcome. I don't want to take you off of your perspective, but I'm not surprised that this would intrigue you at all.
Well, yeah, that was predictable. But I love the way you have framed it, because these are things when they happen. First of all, of course, we look at the human side to it. Okay?
Yes.
We look at the human side to it. There was a lady who was hurt. I'll get into the story a little later.
Uh-huh.
There was a lady who was hurt, and according to the conviction, this other lady knifed her. She was charged with assault GBH, causing grievous bodily harm. Yeah, she was convicted. So it's like she has paid a little bit of a price. She was in jail for 6 months, although she was sentenced to 21 months. And then there's, of course, the lawyer, The lawyer also now really faces a very, very tough time, as much as I think it is very clear that what he did was frankly not correct. You know it as well as anybody knows that when you are in a professional relationship with somebody, there is a possibility of undue influence because of the power imbalance. Because if the client is expecting you to represent them and then you ask for those kinds of favors, the chances are the person might not be really happy, but might say yes. Why? Because of that power imbalance. Okay? So there's no doubt that the lawyer really, overstepped his bounds. But here we are. We all make mistakes. I mean, there was a story about me and the way I told off somebody. Some people didn't agree with what I did. It was reported. It was there. The public discussed it. And I think everybody had a right to discuss that. So I think it is important, as you say, to discuss it in the broader context. But before I go any further, there is always this issue people ask, well, can we discuss this matter? Because it's in court, are we going to be found in contempt? No. Under the Constitution, we have a power, Section 11, to discuss matters, to express opinions, communicate ideas, including ideas of things which are going on in courts, so long as we respect the authority and the independence of the courts. Those are the two words in the section. So long as we respect the authority and independence of the courts. Now, in this particular case, it's even much easier to discuss it because the case is over.
And it's already in the public's domain. But a lot of people probably did not realize that the director has administrative roles, but it's clearly defined exactly how far those roles go. And if you're not satisfied, like the appeal process that we constantly speak about here on this process, due process, you don't have, what they're trying to say is that in this case, he used the right of an appeal, and under a fresh set of eyes, however it was made, this was the outcome. And I felt it was very important for us to look exactly at from a governance standpoint. And when you look even at the Legal Aid Act of 2015, and there's also regulations of 2017, it clearly outlines the role of the director and the roles of the representative, how one is placed on a list and all of that sort of stuff, which is from a civic perspective and for education, hence removing personalities out of this and giving our opinion as to whether or not you agree with the decision. It's clear as crystal there exactly what transpired. Hence me bringing it up today. And of course, I welcome your perspective. And if there's somebody else from a different vantage point wants to weigh on it, 345-936-8255. But I felt it was very important for us to outline exactly the key aspects, first of all, if you may allow me to set the stage here in regards to the Legal Aid Act and its framework. And I will quote, the purpose for the Legal Aid Act, first of all, is that it provides, and because this will make your contribution, Mr. Balika, just make it make sense, okay? Because we can put this into reality. The purpose of this law really is to provide legal aid for criminal charges, specifically with family law matters, child-related, and other civil matters. Now, the eligibility that's covered under this act as well is for applicants that they must pass and meet a certain test to demonstrate financial need and merit, and also a merit test to show a reasonable prospect of success in their case. Now, the administration part of this law covers that a director of a legal aid is appointed to manage applications, establish a roster of attorneys, and determine financial eligibility. And in accordance with the family law coverage that's still also covered under this piece of legislation, is that the legal aid in family proceedings is limited to case involving children, such as the issues with residence, contracts, access, adoption, and even maintenance. And then they also have the operational arm of this act, which is the financial regulations of 2017 regulations that is there. And that is there specifically providing the financial thresholds, including calculations for income, assets, allowable deductions, even for rent or even mortgage. But one may say in the recent developments here, as we are going to use this as the case study to talk about why one was removed or how one was removed from a list in its general broad context, is that this particular case has clarified that the director of legal aid does not have the authority to investigate professional misconduct, and that the powers rest in the Chief Justice under the Legal Practitioners Act. Now, you realize there's two different pieces of laws that we're talking there. But the broader legal landscape of this is definitely from what we're seeing, is shifting with the upcoming, if not already implemented, and I stand to be corrected, Mr. Balika, of the fully implementation of the Legal Secretaries Act of 2020, if I'm not mistaken, that's already in?
Yes, they brought it in like two in two sets.
Okay.
It's now fully in force. Yes.
All right, good.
But it's good. It's good you mentioned that, because when they were dealing with Mr. Keith Myers, the lawyer involved,
right,
they were dealing with him under the old acts, because that's when the events were taking place.
Because what we find now with this modernization is exactly what the word I use. It's modernizing the regulations for all attorneys, but the specific Legal Aid Act continues to govern legal funding. So I'm hoping that in a nutshell, and if we're losing the audience, please by all means comment, because we want you to understand exactly your rights, your laws, and to show you for this particular incident where due process is actually carried out and the powers in knowing your rights. There you go, Mr. Balika.
Exactly. Yes. Well, you've laid it down very well, and I like it that you've ended at what are the powers of the Director of Legal Aid are. Everybody, of course, now should know that this is for people who are particularly vulnerable because they don't have money to pay lawyers.
Exactly.
And so they really are what you would call vulnerable.
They're
people.
Exposed, now, hoping for the best representation and fairness.
And fairness, and then the government helps them with that. Now, you see, the issue really has got to do with like three things: the powers of the director, and whether the judge was right in assessing whether the director had power, and also certain things that the Court of Appeal did. Let's begin with the director. The director, as you said, has got a power under the Act to establish and maintain a list of lawyers who, according to the words used in the Act, who are able.
It's on the screen.
And with you were on the screen. Great. Okay. Who are able and willing to undertake legal aid work. Okay. So what happened was, when the facts of this case arose, the lawyer was communicating with a client in a manner which, let us just say romantic for now. Let's not say, the stronger words, in a romantic way. And what happened was, when he went now to appeal, the issue arose that actually these texts had taken place. It went to the Court of Appeal. I'll return to the Court of Appeal a little later. The Court of Appeal made certain comments about the behavior of this judge, and then the director took up the matter. What the director said was this: yes, I've got a list where I'm supposed to keep people who are able and willing to conduct legal aid matters. But you see, in your case, an issue has arisen that you may have misconducted yourself.
Mm-hmm.
So what I will do in accordance with the principles of natural justice, the principles of natural justice, one of them is that if somebody is accused of anything, even if the law says very, very clearly that if somebody does X, you can remove them from the list, you must still give them a chance to expurgate themselves.
Mm-hmm.
Even if the law doesn't say that, okay, it is implied that you do not take any action like that without giving the person a chance to say, to defend themselves.
Mm-hmm.
So the director sent this letter to this lawyer and says these are the allegations. The lawyer denied them. But after she considered everything and saw the text, apparently, she said, no, I am going to remove you from the list.
Mm-hmm.
And the reason I will remove you is because I can remove people who I do not consider to be able to continue carrying out this work. And she said ability is not just ability to do the work as a lawyer, but it also means that you must professionally conduct yourself properly.
Mm-hmm.
So if you do not conduct yourself properly, I've given you a chance to expurgate yourself, but it appears there's a case, then I can move you from the list. In other words, why am I removing you? I'm removing you because I don't want to spend government money to a lawyer who, as it is alleged in this case, underrepresented this person because they refused their sexual advances, according to the allegation. Okay, because when it went to the Court of Appeal, they said that the lawyers filed some very scanty notes, and apparently he made it very scant because he was unhappy that he was rebuffed.
Mm-hmm.
Okay, so the director of legal aid is basically saying, I'm not going to spend money to somebody who won't fully represent a client, and more importantly, the client is not being protected. How do I allow you now how do I allow you now to go and represent another client? And that client will have no confidence in you. Will say, well, this is the one who made the advances against the other one. And then when he was rebuffed, he underrepresented her. He didn't put enough effort into the matter.
Mm-hmm.
So you see, though that would have been the reason that the director acted like that. They did explain it in court, but I'm just trying to contextualize it a little more in terms of how, from a government side, they would have reasoned it. So she said, fine, I'll remove you from the list. Now, removing somebody from the list does not mean you are suspending them from practice.
Mm-hmm.
It just means that you can't take legal aid matters. You can still practice and go to court and take other private clients. But he was saying basically it hit him hard because most of his business was legal aid.
Mm-hmm.
Okay, so he took the matter to court, and the court looked at it, and Justice Marlene Carter said, "Look, Director of Legal Aid, you don't have power to discipline anybody. The power is vested in the Chief Justice. This is under the old law before it changed last week or the week before. Yeah." It's the Chief Justice who had the power.
Mm-hmm.
And there is a provision there where the Chief Justice can have an inquiry and so on. So you have overstepped your bounds.
Mm-hmm.
Then he said, well, I will therefore reinstate this lawyer to the list. But I'll tell you the problem, Sabrina, with that. I disagree with the judge 100%. The Director of Legal Aid was within her power, and I'll tell you why. You see, under the interpretation law, there's a provision which says that whenever a public authority is given power to do something,
mm-hmm.
then you must imply in that power other powers which are reasonably necessary for them to be effective in that role. Let me give the simplest possible example. Imagine you've got a hotels board and you say the hotels board is given power to give licenses.
Mm-hmm.
But you do not say whether they can revoke licenses, whether they can suspend licenses, whether they can give licenses conditionally, and so on. The court will say, no, if you've got the power to license, it is implied that for you to be effective in that licensing capacity, you must have these related powers, such as power to suspend or to give a license with conditions.
Mm-hmm.
So if you translate that now into what the director did, she was just saying, look, if I can put people on the list here, I've got implied powers to take you off if you are not acting professionally, in my view, for purposes of legal aid. The Chief Justice can do what he wants to do to discipline you generally, like even to remove you from the road, to strike you off the road, to suspend you, to fine you, and so on. But I will do from my corner of the civil service that which I will do to protect government funds and to protect clients.
Right.
So the judge, in my view, was wrong. The director was right. What the judge should have said is, well, look, you have not been denied right to practice. You have just been refused the right to be on the legal aid list. That's not a right, a fundamental right. That is something that the director also has got certain duties. That is my view about what the judge did. But then the Court of Appeal now was very problematic what they did. Okay. Before I go to that, the judge, in my view, gave the lawyer a bit of a pass. Okay. He gave a bit of a pass. And I'm asking myself, if lawyer had been a Caymanian, do you think that this judge might have said the same thing? According to what we know, how Caymanians are usually treated? Okay. When we talk about how the ombudsman is now, they want to get rid of her. Why? Because she was banging the table. She didn't give sufficient feedback. Do you see when you see the two of them, they want to get rid of her for those little tiny things. But the judge is saying, this judge, who is not even being dismissed or disbarred, they are just saying you can't take legal aid because of this matter. And in fact, once the matter goes to the Chief Justice and is disciplined or not disciplined, he could still apply to come back, to be reinstated. So for me, I think these are some of the things which we will always ask these questions. It appears to me Ombudsman is being harshly treated. This lawyer was given a pass on this one. But having said that, I think the Court of Appeal was very unfair to him. And I'll tell you the reason why. You see what the Court of Appeal, what did they say? The Court of Appeal said, look, we are very troubled by what you have done. Therefore, we are asking that this matter be brought to the attention of the disciplinary authorities in the UK, in England and Wales, as well as the disciplinary authority in the Cayman Islands. In other words, the ones who now have registered you to practice. And then they say, it should also be brought to the attention of the DPP, the Director of Public Prosecutions, so that, quote unquote, he can move the matter forward. Move the matter forward. Isn't that saying that asking the DPP to prosecute him for a criminal offense? Because first of all, the DPP has got power under the Constitution to begin, to continue, and to discontinue any prosecution. And in exercise of that power, they are not subject to the control of any other person or authority. Doesn't this appear like an attempt by the Court of Appeal to either direct him or influence him to prosecute the person? To me, that's the way it looks. Because what he should have said, what they could have said, the Court of Appeal, I'll tell you what they should have done. They should have said, look, for purposes of us deciding this appeal, we are not satisfied that this client received appropriate representation. The submissions by the lawyer were very scanty. We think it is plausible that maybe they were very scant because he was rebuffed by this client. So in terms of the justice of this case, we will allow the appeal. In other words, the appeal succeeds, this person is acquitted, the case is over. So that's what we will do for our purposes. But what it should have done, having done that, if it felt that they could say something about what he did, they could have said, look, we won't say anything about whether or not the authorities in England or in the Cayman Islands who discipline lawyers, whether they will want to look at this. They have their own powers. It is now in the public domain. If there is a complaint, they can look at it, but we won't comment on it. Also, they could have said, look, it is possible that a criminal offense here may or may not have been committed, but we can't say that because that's the power of the DPP. So we will just say that let the DPP have a look and make up his own mind whether, in his view, he wants to prosecute or not to prosecute.
Mm-hmm.
Do you see? That way, then they wouldn't have prejudiced the case. But the way they talked, they have prejudiced the case now, because now the disciplinary authorities are under pressure from this high-powered judge, three-panel judge, which has said, well, this is troubling and so on and so forth, and telling the DPP, move it forward. That to me prejudices it. And I'll tell you how that can have an effect. It had an effect on me.
Mm-hmm. Mm.
There's a matter when I went, there's a time I went to the Court of Appeal on a certain matter. I went to the Court of Appeal. The judge in the Court of Appeal said this matter should go back to the Grand Court so that the Grand Court can have a full hearing, call witnesses, have documents produced, and so on. And the Attorney General and the Governor agreed. Okay?
Mm-hmm.
But then, having ruled that it should go to the Grand Court, in his last paragraphs, he said, having said that, I think that this case has got no merit. It is unlikely to succeed. Now, 2 points there. One, he shouldn't have been saying that, because the truth of the matter is I had established with 13 hard copy emails that the judge was lying about what I had done. Okay, he lied. So first of all, it was not correct for him to say it had no merit. If anything, it is the judge who had no merit. That's point number one. But point number two, whenever a Court of Appeal judge refers a matter to any authority or to a lower court, they should always say, I refrain to comment on the pros and cons of this matter because I don't want to prejudice it. Do you see? Because when you are a Court of Appeal judge, you send it to a lower court judge whose decisions bind him, then he feels he's obligated to agree with the judge. And that's what happened. Once I had got there, this judge clearly was already influenced, and I lost that case. And by the way, that case now has just gone round in circles. I just got a letter from the Court of Appeal in the last hour. The Court of Appeal will be hearing it, and some special judges will be appointed to hear that. But that's I'll talk about that another time. Let's talk about this matter. So, do you see? So the Court of Appeal, in my view, has to be more careful. Let me give you two examples from the past one example from the past where again the Court of Appeal messed up. You remember the Chantel Day case?
Yes.
The same-sex marriage case. Yes. It went before Chief Justice Smelly. Chief Justice Smelly decided that he was going to amend the marriage law so that same-sex marriage should be allowed in the Cayman Islands. It was appealed to the Court of Appeal, and the Court of Appeal said that Chief Justice Smelly was wrong. He had no power to amend the law. However, they said, the government had an obligation to allow civil marriages, because those were implicitly allowed under the Constitution as a part of the right to family life. They were allowed also under the European Convention on Human Rights, and also there are a lot of cases which were determined by the European Court of Human Rights. So they said this matter should... Okay. But then you know what they did after they decided that, which they had the right to do, because under the Constitution, if something is unconstitutional, they can make a declaration of compatibility, which they did. But you know what they did? After they did that, then they said, well, the government now is obligated to pass a civil union act. And if it doesn't pass that act, then the UK government should pass an order in council to force the government to do that. That latter part of it, the Court of Appeal had no jurisdiction to say. And I remember one other lawyer who also speaks on radio a lot, he also said the same thing, because all the power that the Court of Appeal had was merely to say that this is incompatible with the Constitution and the relevant human rights instruments. And so, since it's incompatible, we are now passing it on the government to do what is necessary. But instead of doing that, they made now a political statement to say, if the government doesn't do this, then the UK government should do that. They shouldn't have said that.
There's actually cornering the government too. It's like drawing them out.
Exactly.
It's pulling them out, whereas it shouldn't have been involved.
Exactly. And so to me, I think what the message that I would send to this Court of Appeal is behave like a Court of Appeal. When you are up there, whatever you say will prejudice people. Keith Myers will now be prejudiced when this matter is heard by the Chief Justice. He will be prejudiced when the matter is heard by the people in England and Wales. It will be prejudiced also even with members of the public. Now, the evidence, I think, is quite strong, to say the very truth, but that's not the point.
Yes.
The appearance of justice is very, very important. By the way, I don't think that, in my view, that he should be disbarred. I think he made a serious mistake. Maybe he might just be suspended from practice, perhaps. Maybe sometimes he can also be fined. But I kind of think that disbarring him will be too harsh a penalty. But that's my opinion.
But who would make that
these are
call?
sorts of-
Who would make that call? Would would they have the whole case? And we're not preempting anything here. It's just a matter of what happens next because of the very sheer nature of our jurisdiction. You can look at it from both sides of the coin. That's his livelihood, and the ruling was made. You know, at the end of the day, even if he gets put back on the list, like you rightfully said, he's not prejudiced. Since he is, I assume he's called in England and Wales. That's why the judges say that that the bar association there should look at it. Those will be the ones, like they could, if he is to be disciplined by that, well, he can be disciplined by both the Chief Justice. He can also be disciplined by the bar in England and Wales, since he's a member of both bars. Now, in Cayman, I don't know how it will eventually work, because I would imagine that the new tribunal would take up the matter. Because usually what happens is that if a matter is pending before a previous authority and then a new authority comes in, any pending matters would move to the new authority. So the chances are that this will go to the disciplinary tribunal of Cayman for attorneys. It will also go to the board in England and Wales. In the end, we will have to see what happens. Now, sometimes it happens that when these boards make a decision, the matter comes back to court, and then it goes to the Privy Council. There was a lawyer called Tim Pollane. This was a lawyer who was involved with the Tempura investigation. There was some problem which arose. The Attorney General accused him that he was practicing law without being licensed, which was ridiculous, because if you are hired by the Attorney General, you don't need a license, a practicing license. That's why when I was in government, when I worked for government, I didn't have a practicing certificate. I was qualified to get one, but I didn't need one when I was in government. But when I went into the private sector, then I had to get a practicing license. But anyway, that's another story. So that guy, what happened was, they reported him to the bar in England and Wales, and those people there disbarred him. They're saying you were practicing without a license. So he now took it all throughout the court system until it went to the Privy Council, and then the Privy Council said, well, look, this was not such a serious matter since you were engaged by the Attorney General, but still you also had the responsibility to know that you needed a certificate or something. And then they reinstated him to the role. I think fined him 1,000 or 2,000 and so on. But he really paid a heavy price, because it took about 2-3 years for all that to happen. So that's what will happen. So, either the bar in UK will discipline him, or the disciplinary committee in Cayman. Even though the ruling was made with the decision to have him relisted.
Well, that decision now is effective in that he has been relisted, but purely for the purposes of legal aid. So now what they will do is they will look now broadly at whether he is fit to practice at all.
In general.
Okay. In general. Yeah. Because that's the remit now of the disciplinary tribunal in Cayman and the bar in the UK. They will now look at it and say, okay, fine. They've restored him to practice and so on. We are not directly concerned about that. We are looking at, is he fit to practice? Because if they say now that he is not fit to practice and they strike him off the roll, then he can't, of course, be on the list, because you can only be on the list if
end up right off again. Yeah. So what?
but I think it would be a harsh penalty. Yeah.
What does that look like? Again, going back to the sheer size of our jurisdiction and how these issues can actually impact someone's reputation and life on it. And this is just broad brush now, looking at this, because this section of the law, section 11.3 of the Legal Aid Act, it clearly says and outlines the administrative responsibilities. But then when you look at what and it sets out the clear limits, but then the ruling, as you rightfully said, because we had it up here just now, about the list and everything, right? When you look at removal from a list, it says 11.1, and I'm going to read it for just emphasis. The director may, after,
yes.
yes, the director may, after supplying an attorney at law with concerns which could result in his name being removed from the list and giving him a reasonable opportunity and time to respond to such concerns, remove an attorney at law from the list prepare pursuant to section 7, subsection 2 says, where the director removes an attorney at law from the list under subsection 1, as I just read, he shall provide him with written reasons for the removal. And I continue subsection 3, when an attorney at law is removed from the list pursuant to subsection 1, he may appeal the removal to the judge in chambers, who may order the reinstatement of the attorney at law. Subsection 4 reads, a decision under subsection 3, as I previously read, shall be final. So you rightfully agree that the role of the director wasn't in accordance to law, but in subsection 3, obviously they were disgruntled and they appealed it, and here we have the ruling of a judge in chambers as cited under this piece of legislation.
Yeah, and so I mean, the judge, of course, had jurisdiction to hear the matter. Although I think that she made a wrong decision. She had the power under subsection 3 to hear it, and for a decision under subsection 3 shall be final. You know, yeah. You see,
that's the big one.
A similar provision.
That's the big one. Subsection 4 is big.
Yeah, subsection 4 is big. You know, it's got, in a broader legal context, there are two meanings of final. Okay.
Okay.
Yeah. Let us imagine that you, I don't know. Let us imagine there's a tribunal, and the tribunal hears a matter, and then it says that the decision shall be final. The courts have always said that if you say that in relation to a body which is part of the executive, okay, the decision is still subject to challenge under judicial review.
Judicial review. Okay, so it's not final. It's just another stage.
It's not exactly. But in this case, this decision is said to be final, and it is given to a court. The way courts have treated this, they've treated it differently, because in Cayman, you remember, under election, you know, you are a former elected representative and minister.
You keep bringing that up.
That provision, which I love to say that to remind people. You see, you remember the election petition. If you bring an election petition, and the chief justice, the Grand Court decides it. Usually, it is the chief justice. If the Grand Court decides, it says the decision shall be final. It has been held in the Cayman Islands that final means you can't appeal it on any ground. Okay. Right. So when it is given to a court, what Cayman has said is, if it is final, it is final. You can't appeal it on any ground. Right. But if it is given to an executive body, in this case, it is final, you can still appeal it by way of judicial review. Okay. But you know that judicial review is very narrow. Judicial review doesn't try to do or undo the decision. All it says was the decision was lawful. Once you say that the decision was unlawful, and you give the grounds on which it was unlawful, it can still go back to the body which made the decision. They can correct those errors and either still dismiss you. So it might be an empty thing. Yeah. But in this case, I think the intention must have been the same as under the electoral law, since this is stated in relation to a judge. So in Cayman, the way it is understood in that context, you can't challenge it even by way of judicial review, because you see, Grand Court judges anyway are not subject to judicial review.
Correct.
The ones who are subject to judicial review are magistrates. It is very rarely.
Really?
It's very
So there's a
rarely used.
distinction
Yes.
between the Grand Court judge and the magistrates.
Precisely. You can sometimes appeal a case from the magistrate, or sometimes you can bring a judicial review against a magistrate, but you can't bring a judicial review against a judge. So that's some nuance in there. But you know, Sabrina, in the broader context of this matter, I think what people need to do is to say, here is an unfortunate person. I think in one respect he was treated well. In another respect, they treated him with kid gloves. And regarding treating him with kid gloves, then that's when we can talk about people in Cayman. For example, I've already talked about the ombudsman, but you can also talk about a poor paralegal who worked for 20 years in the portfolio of legal affairs over something which she could have maybe just even been disciplined. They ended up prosecuting her with a jury and she lost her job. And yet you had that other policeman, British policeman, assaulted a Jamaican police officer. He was never even disciplined. They transferred him to the BRAC, and I understand he's having a very, very good life now in the Cayman Islands. You had the other gentleman who I think took a truckload of marl and went and dumped it somewhere. I think it is his father's farm or something. They charged him with a breach of trust. So they charged these people who are lowly people in society. They easily charge them with these offenses, and yet a person like this one, they gave him a pass.
Stick a pin.
I think that has.
Let's get you to weigh in on this comment posted by Alfred Reel.
Sure.
Good governance isn't just about whether a decision is legal. It's about whether it's legitimate in the eyes of the people it serves. Checks and balances only matter if they're visible, understandable, and open to challenge by ordinary Caymanians, not just lawyers and insiders. When rulings feel distant or technical, trust erodes, and without trust, governance becomes compliance, not consistent. And they admitted that tonight's discussion is important because transparency is the price of authority in a democratic society. They also said, sorry, can I read some more? Because there's a question that comes up. And continued by Alfred Reel, Auntie Sabrina, in a small society like Cayman, where decisions ripple quickly through families and livelihoods, should transparency be treated as a higher duty than mere legal compliance? And when people feel shut out of decision that directly affects them, is disengagement really apathy, or is it rational response to systems that doesn't meaningfully invite participation? Now, Alfred, I gotta give you a kaboom for those questions.
Me too.
It aligns exactly into the civic space that we're trying to create. But I'll give you, my learned friend, the opportunity to respond to these hard-hitting, thought-provoking questions.
You know those questions. That person understands between the difference between rule by law and the rule of law.
Yes.
You see, rule by law just means that you comply with the letter of the law. But sometimes you can comply with the letter of the law, but leave people still unfairly treated. That is why there is a broader concept of the rule of law. The rule of law is a broader concept than just technical compliance with the law. There needs to be, people should understand, like when a decision is being made, They must feel it's fair. Yeah, you could even give them a chance sometimes to expurgate themselves.
Right.
But then you might make a decision that is so bad that it is totally untethered from even the submissions they've made. Okay, in terms of the law, you have exercised that power. You have the power to do it. But if it is not transparent and it is unfair in other ways, which sometimes even the law can't touch, that's a problem. For example, when the DPP prosecuted this paralegal, the DPP complied with the law. The DPP has power to prosecute. Did this person do something which was called prosecutable? Yes, because she was alleged to have held on to a file too long, and therefore the period expired. Okay, fine. Technically, yes, that is something you can prosecute. But really, in the circumstances, did you need to take the person to court? Couldn't you discipline them, suspend them without pay for 1 month, for 2 months? And it was not really like an important offense like a murder or something. This was about somebody who had a joint, a teenager who had a joint. Okay. And so you say, oh, you held on to this file, and therefore, now you are going to be prosecuted. The other thing also is that why didn't they prosecute the Crown Counsel? Because when she got the file, she didn't hide it. She went to the Crown Counsel long before the period expired and said, well, this is my son. Please, can you just warn him, and so on and so forth. And then when the time expired, they prosecuted her, not the Crown Counsel. In fact, to me, the one who should have been prosecuted is the bigger fish, but they ended up prosecuting
the little
her.
one.
You see, the rule of law requires a much greater compliance with the issues of transparency, fairness, and so on, even going beyond technical compliance with the law. And in Cayman, we are lacking, I think, the rule of law. But let me also say something about the politicians, right? The politicians are the ones who should really be assisting the public in promoting the rule of law. At the moment, they are not doing this. In that case where, although this one is not really about the rule of law.
Tell me how you come to that, and how they could do it. Tell me now, to be honest. Be very honest. Be very candid.
Okay.
How?
Yeah. How they would do it is, we've sort of discussed it a little bit before. They need to exercise their power in Parliament to question why certain things are being done. They need to do that. For example, you see this case, where the Court of Appeal said, well, if the government doesn't enact the law on same-sex marriage, then the UK government should force it to enact it. The politicians should have said, hey, we are going to do this because we believe in the rule of law and we believe in the law. But it is not your job to enter into the political arena to now say, if we don't do it, the UK government should do it. The politicians should have come out and told the Court of Appeal, that is not your job. Under the Constitution, you have got a power to make a declaration of incompatibility. You have done that. We are going to go ahead and do it. But it is not for you to say that if it is not done, it should be done by the UK. The politicians should come out and make these statements. They should also be able to go to Parliament when they are considering these reports from the DPP and so forth. They should be able to say, DPP, do you have a manual which guides you on prosecution? Because, like, for example, in Ontario, you have, like in a lot of other places, you've got the powers of the DPP to prosecute, the Crown to prosecute. But there are certain guidelines which are given to you to exercise the discretion. For example, in some cases, they would say, look, if technically there has been an offense and the person is not, like, for example, somebody used some profane language. Okay.
Yeah.
You use some profane language. Maybe they just said it once and they said it to a police officer. You could maybe arrest them. But once you arrest them, you would say, look, do we want to go to court and prosecute this person on this? He is not a habitual offender. It was just a very technical thing. Then you wouldn't prosecute them. So there are a few guidelines which say, is it worth us prosecuting this person? Is there any public need? So those are things that government should press people like the DPP to produce a manual which guides those things.
I agree.
You remember that?
Stick up in 1 minute. Going back to exactly what you're saying, it's the duty of the members of parliament, your elected official, to educate.
Yeah.
Now, I see Denver's comment, but the blurring of lines in especially young, or maybe even those who are seasoned, in understanding how far or how close that line is drawn, and especially if you're with a collective responsibility in a group, you don't want to go off, you understand? Some of these things, unless they actually come into the public space and there's a public outroar, there's a cry, or your phones are going crazy and all of the MPs' phones are going crazy about a particular matter. Many a times, I'm being very honest with you, as you alluded to with the same sex, where government was actually pigeonholed and it became politicized. They wouldn't know. It is not clear how far one can go to defend it without stepping on the toes of your colleagues. You will more than likely, and speaking from previous experience, would be stepping on toes. And you would be looking at it, but you're there to serve the people. Make it does not fall within the confines or the context of your specific ministry. And I'm just speaking off of previous experience. I'm not pointing any fingers now. It is for the context of exactly what you said. How are you going to go out there based on the environment that I left and educate the public on exactly what I'm doing here now as a former member of parliament? Sir, you really cannot do that when you're in there based on the environment.
You know, Sabrina, this is really important, because the point that you are mentioning, because it is not enough that, okay, something wrong is being done, and then you arrogate to yourself the responsibility to correct it if you don't have the power to correct it, because that's also a problem. Okay? Because there are sometimes, for example, a politician can say something which impinges upon the authority of the courts. You can't do that. Okay, so there is always this thing that every minister has to know where their power begins and ends.
And you have to get permission from your premier. Remember, you're sitting there at the pleasure of the premier. You can bring it up in your monthly, quarterly, weekly, bi-weekly, however often you meet with the premier, to say, these are matters that is important to me. This is what representation, for example, that's being made to me by my constituents, by a large number of persons within the community that don't necessarily have to be in your constituency that you represent. But hello, have you listened locally to hear that it's very topical now on all the radio stations, on all the social media platforms, that this particular, just using example, is coming up? Don't you feel that we should actually address this as a government? What would you say? You could be shot down. You could be saying, oh, I'm going to offload this on somebody else. What do you do? So I'm following you with knowing the duties, but of course, those duties rests on whatever permission you get, especially if you're a member of cabinet, on what what permissions you're given from your premier, unless you become a rogue MP.
Yeah. And you know, it's that issue reminds me of this matter which has been going on, where politicians say, hey, our people say they want better preferences for Caymanians in jobs. But then when we go to the deputy governor says that, well, you can't appoint people. Okay, I'm the one who can appoint people. And then the politicians say, oh, but you see, you are making us look like we don't matter, because one of the things that we are elected to do is to broaden opportunities for Caymanians to get into jobs. And I remember the time when Kenneth Bryan and the Honorable Franz Manderson, both honorable people, were on. This was before the elections. They were on. Yes. Yeah, they were on it, and I remember Kenneth Bryan saying, "Look, you can't keep telling us that, you see, we can't appoint people. Yes, we don't want to appoint people, but we want to be able to appoint to influence the policies in such a way that those opportunities can open up."
Mm-hmm.
And to me, what I suggested, it wasn't on that show; it was on another, the same show, but not on that particular one when the two of them were on. What I told OC, I said, you know what, this is not supposed to be complicated. What you should do is ask Franz Manderson as deputy governor. Say, Deputy Governor, our people feel that where they are not getting enough opportunities, not enough openings. Can you draw a program, maybe for 5 years or maybe for 10 years, which will create spaces for Caymanians to be trained and to continue rising?
Mm-hmm.
Okay,
Mm-hmm.
we will not, as politicians, we will not appoint anybody, because under the Public Service Management Law and also even the Constitution, we can't appoint anybody. But we want you to meet these targets. Can you meet these targets?
Mm-hmm.
And the deputy governor might say, well, I can meet them if you give me money to train people and you recruit people to train and so on and so forth. And then the two can complement each other. One decides the policy and the targets,
mm-hmm.
while the other one implements the policy. Then every year, every 6 months, the deputy governor can go before cabinet and say, well, that program that we agreed on between you as politicians, as
mm-hmm.
cabinet, and me as the head of a civil service, we have been implementing it. It is working well,
mm-hmm.
but we need more money.
Mm-hmm.
Okay? And then they give you money. So do you see how then the politicians are not just sitting there and saying we are not appointing anybody, but they are all influencing the policy and working with the deputy governor so that he can exercise his powers better.
Correct.
Yeah.
And you see, this is where public education is key as well, because a lot of people did not understand the roles of the operational arm of government, the civil service, and your elected
mm-hmm.
arm of government, the politicians, the MP
mm-hmm.
that you actually elect, and saying, okay, this is the campaign trail. This is what we're going to do. Once you elect us, this is what
mm-hmm.
we're going to do. But hold on,
mm-hmm.
you're elected. Then the government has to form a government. That could be exactly a composition of a mix of independents, a mix of two different parties. Okay.
Mm-hmm.
Then what?
Mm-hmm.
What you have said, because of single member constituencies now, you, the people, are going to hold you to what you said in that small electoral area because of the single member constituency, for what you said you were going to deliver nationally, locally, not realizing, if you're fortunate or unfortunate based on how people look at it, ending up as a cabinet minister, maybe for the first time, that they're
mm-hmm.
competing priorities, because you're not only now looking for the constituency that you represent, which is the only key to get you elected. You have to please them.
Mm-hmm.
You're also
mm-hmm.
looking at it nationally, and they no longer, you can't, as a sitting cabinet minister, be speaking as though you only have the responsibility of representing those who got you elected into office. You have a national responsibility to represent every single individual and speak and conduct yourself in that manner with the ministerial responsibilities that have been given to you under the Constitution. But because a lot of people did not understand or do not understand how it operationally works, do you realize where you're pointing out the problem? And it aligns with exactly what Denver keeps saying, that this SWAT sessions are needed, not only internally, but from a civic perspective as well, Mr. Balika. And we have failed our people in educating them until now.
Well, you see, this is why, for example, this issue of district councils continues to be a hot topic,
Mm-hmm.
because when that law was passed, I worked on that with Steve McField. Steve McField really is the one who really did the major research, and for a long time, I came in towards the end to just reduce it to writing. But you see, I thought at the time that actually government was very serious about it. Now, these are district councils which will just be advising the minister. Okay.
But they're also paid roles. They're also paid roles. And I feel what was actually, in principle, did not end up in legislation. Let me repeat that. What the essence was supposed to be, and I stand to be corrected. Maybe that's an episode that we need to carry, because I'm understanding now that there's some constitutional amendments that would need to be done in order to have that legalized. What was agreed to in principle of how it should look was not what it ended up being when it became a piece of legislation. You follow where I'm going with that?
I see.
Because now certain positions are paid positions. You would have needed funding. How would have been the recruitment process of those? And then you had well-organized oil machinery already doing certain things within the district or in areas before electoral boundaries. Remember, single member constituency scheme after the fact. How would you amalgamate those? How would they be incorporated? And then you have a lot of these good members of civil society being a part of their community that are also civil servants. If certain positions, as in that document, would be paid position, would these civil servants who are just members of civil society but want to give back to their country and be a part of the solution in their communities, would they have been barred from remaining there? So I must say, there's a good start. But when they realize the amount of power those councils would have had, as the end result showed, you read in between the lines.
Yeah. You see, I'm just looking at the section now. The Advisory District Council says, subject to this constitution, a law enacted by the legislature shall provide for the establishment, functions, and jurisdiction of councils for each electoral district to operate as advisory bodies to the elected members of the Legislative Assembly. And that is all it says. That's all it says. And now, so the law ended up now, providing for the procedure and so on, but they are still advisory. But I'll tell you part of what I think is the problem with that Advisory District Council. One, anybody, or before I talk about the problem, anybody which will assist with the consultative process between people in the community and a member of the Legislative Assembly is good. Because sometimes things develop in a certain way because there's miscommunication, misunderstanding, and so forth. So anybody which facilitates consultation is good. But having said that, since these bodies are merely advisory, I'll tell you what I learned about ministers in general. Ministers just generally don't like to be advised unless they ask for the advice. Let me give you an example of one piece of legislation I was working on. I'm still bound by secrecy, so I can't tell you which particular one. But when we were dealing with that legislation, I was drafting a provision which has to do with how cabinet appoints the members of a particular body of, executive committee. So the people who were sponsoring the legislation, they said, you know what? Why don't you put in this law that the chief officer or the director of something shall recommend names to the cabinet, which for consideration for appointment. So I told these people, I said, you know what? I told them, I said, ministers don't like that. They always like to start on a clean slate. Because the reason they want to start on a clean slate, because they don't want you to name people. And then they go to cabinet, and then cabinet says no to this one, that one, that one. Then it's on the record that the cabinet didn't want X. Ministers don't like that. Okay, ministers like it to just say, okay, I've got a power to appoint. Okay, fine. The minister then will sit down, maybe just brainstorm it a little bit with the chief officer and a few people and so on. Then they decide on some names. They take those names, they take them to cabinet. So that if there was anybody who was rejected, there's no record that they were rejected. But if you put it in the law and you say that a certain body or a certain individual will recommend names, then it means that person will recommend names. The chances half of them won't be appointed by cabinet, then it becomes controversial because people will get to know that this one was not allowed and so on, and then they get into, oh, maybe it was for political reasons and so on. So I would imagine that that same attitude is what is influencing this idea about district councils.
In the sense of
councils
apathy. It is not on the top of a priority list because they're realizing there's already a foundation. As simple as you may actually have read that, okay, it's deep. If you really dissect that, that's deep. That you could go in multi directions with that. That actually makes it political in its very own tone. And if you want something to be neutral, but yet it's advisory body and how you look at how it's funded and all that sort of stuff, how can you separate that from not being political in its original context? And this is where you have to be careful with where it goes, is some of the discussions that I've heard.
Yeah, and then you see the members of these councils, all of whom are to be appointed by the governor and cabinet. Okay.
You see what I'm saying? So how can it not be politicized?
Yeah. By its very nature,
exactly.
Because it goes to cabinet.
Exactly, sir. Now you only went round full circle with what I said in the beginning. So you can't say that it's free of being politicized when, from its very nature, repeat what you just said.
Yeah, from its very nature, it is political because, I mean,
I rest my case.
If the governor and cabinet is going to be the one to appoint, then they want to want certain people who make certain kinds of suggestions which they don't like. Okay?
Exactly, sir. It goes right round, full circle. So thank you for realizing how you came right round.
No, you're right. You're right. You know, because then it becomes. Then you see. Then you reduce it to somewhat of a sham. It can still play a role, I guess, but it becomes a little bit of a sham because now these people are not even like appointed by constituents or suggested by maybe some associations. You know, there are a lot of associations in Cayman, right? It's cabinet saying we want these people to be the ones who are advising us. For example, in C, they say, okay, there'll be a chairman, vice, secretary, treasurer, and then not exceeding 6 other members, at least 2 of whom shall, subject to subsection 2, be recommended by the leader of the opposition appointed under section 68 of the Constitution. And in making appointments, the governor and cabinet shall be cognizant of recommendations made to him from within the electoral district. But you see, that's very vague because who is the electoral district? It's not as if there is a body there which actually will recommend these people. This was just something they tagged onto, which has got no meaning. It's not something that you can even enforce. So this found its way in the Constitution. It's very surprising why it has not been given the teeth it requires.
And where is the Constitution amended, caller? Where is the Constitution amended?
In the good United Kingdom of Great Britain and Northern
that's
Ireland.
Not something that can be done by a motion on the floor of Parliament. That has to be taken to the United Kingdom and asked for it to be amended. And you have to find out whether or not that's on the top of a sitting government, a sitting administration's priorities lists. So when you're hearing these things about district council and we're going to do it, unless you're prepared to amend the Constitution, which means you're taking it to the United Kingdom in hopes they actually support you in what recommendations for amendment or for more clarification, it's not going to happen. You can create a group, a hybrid, but can you label it as it's defined in the Constitution as a district council? No, you cannot, because there's some amendments that needs to be made in the United Kingdom.
Yeah, you see, this is why these bodies, which were created by 2 MPs, I won't call their names. One was I think 2 MPs, one in West Bay, the other one from elsewhere. Now, I don't mean to blame those people.
No, we're not casting blame. We're educating. We're educating the public.
Exactly. Yeah, exactly. It's like those are not district councils within the meaning of this law. Okay?
Correct.
Those are more like ad hoc councils just created administratively by the MP, which they will use to the extent that they want to. But the Constitution envisaged that there should be district councils which perform certain functions. But you see, the other thing also, Sabrina, is this. It also, a couple of things. One, I think it is time there was a review of the Constitution. Okay? A review to say, okay, it has been enforced now since 2009. And how has it worked? I think there are a number of issues which have arisen. Some of those which have arisen are real big political issues as to how do you elect the premier. Okay? Because this has become, from my Cayman groups, there are people who have given this a lot of thought. I have also given it a lot of thought. There are some people, for example, who think, now I'm one of those people. I think that the premier should be directly elected. Okay?
And chosen by the people, the electorate?
But yes, because in some countries, the way they do it, except those are like presidential systems. They have hybrid systems like Westminster system and presidential system. They would have during an election, you've got two ballots. You've got one ballot for your MP. The other ballot is for the president. You could vote for a president who is not a member of the party that you voted for, and that gives you as a voter real power. Because at the end of the day, you are tying me to a party. You are saying that, you see, when I'm voting, I only vote for an MP. I don't know whether that MP will support the premier that I would have supported or not, because that becomes a matter of horse trading at a certain time. And yet, who the MP is going to be, or who the prime minister is going to be, can sometimes affect the whole election. You know what happened? You remember what happened in Canada with the last election? In the last election, Justin Trudeau, just before the last election, Justin Trudeau's numbers went down. And the Liberals went down with him. And they were behind, I think, in the opinion polls as much as some of them, 25%. Okay. When Trudeau resigned and Mark Carney took over, they were able to make up that 25% and got more and ended up being elected. Well, how did that happen? It happened because people liked Mark Carney. Okay, so it's as if they decided, no, because Mark Carney is going to be a prime minister, I will vote for that MP who is in Mark Carney's group. So that does matter. I know some people in Cayman who even think that even ministries, like people should go to election to be elected as Minister of Finance.
Oh, really?
I know people like that. Yes,
Okay.
I know people who, and they have elaborated this very, very carefully because they are unhappy with this idea that you get in, you do not know who the prime minister, the premier is going to be, and then later on there's maybe a little coup. I think now Cayman government has become a little bit more stable. You remember that time when this is before you entered politics? There was that other government for 6 months, and then this other one came back in. No. That's one of the problems I have with the Westminster system of government. Sometimes a coup in an opposition party or in a ruling party can bring down the whole government, and then sometimes you can call an election whenever you want. Like in Barbados now, they've called an election. No, I prefer the American system where the elections take place at a particular time. Okay, and the way the American system is built, as you know, is such that you can't bring down a government by a vote of no confidence. You can remove the president, you can remove certain members of government, but otherwise a government is guaranteed for 4 years. And the founding fathers of American independence, because they studied the British system, they were educated people. Basically, they started off to say, our default position is we don't want to do what they do in the UK. Okay. And we don't want to do it. We don't want church and state to be lumped together. We do not want anybody who holds office to be obligated to be Christian or this and that and so on. And so they decided that there are some things they were going to get from government, from the UK, and they did. But the default position, they say, look, we want things which are different from what they do in the UK. So that's why they also establish a system where you can't bring down a government by vote of confidence. They just had these pieces of legislation where you can impeach the president and the judges and so on and so forth. I personally think really there should be a real look at the Constitution. Are you there? I heard a ping.
That was a WhatsApp coming in.
Okay.
Ms. Denver actually agrees with you. Yes, our premier should be duly elected, and I just need
elected,
I just needed for the context of this conversation so that everyone follows. You said that the amendment to the Constitution, as we know, has to be done by the UK, but there's also talk about people not being happy with the single member constituencies. And even though that is something that would be nationally topical, whether or not persons would want to go back in, be it a national vote or go back to a similar system that what we had, we need to make note that that would be an amendment to the Elections Act for that. But the voting for the premier would require the amendment to the Constitution, not how the elections are carried, for the context, because it's two different things. Everything ties into one. And I just don't want people to think then, we would have to change the UK's constitution for Cayman, as Danny loves to put it, if we even wanted to change how our election process works. The only amendment to the Constitution that would be required is if we wanted it to be the how the premier is chosen. That would require a constitutional amendment. But to go back to a hybrid of what we previously had and remove the single member constituency as it currently is not and would not require an amendment to the Constitution. That would require an amendment to the Elections Act.
I'm not sure about that, actually, Sabrina, because you may be right. I'm not saying one way or the other. It's just on radio or off the top of my head and so on. I'm not quite sure about that. But let's put it this way. There are certain things which we can amend in terms of elections by amending the Electoral Act. Okay? You remember one of the most controversial provisions in the Electoral Act, this is going further afield now, that a member of parliament who is sentenced to a sentence of imprisonment of 12 months or more, or exceeding 12 months, then they can't stand for elections. But then you see, people ask the question, they say, look, why does it have to be exceeding 12 months? If I'm sentenced to imprisonment for 2 months and I want to apply for a work permit, I have to disclose that I've got a conviction. How come the standard is much higher for me just to get a work permit or to work or to get a job, while for somebody can be sentenced to 11 months imprisonment and come out of jail and still run for election?
You see, it all depends on the nature. That's one of the things too, as well, that has been broadly talked about, nature of offenses and what could qualify and disqualify. Because right now, say for murder, that's the only thing that would bar you, pretty much. And I, again, stand to be corrected for that, right?
Well, it's
going down another rabbit hole here.
Another one, but this is important because you see, because this is a broad subject. Because what jumped into my mind as you were saying that, it's this, when they were, I wrote the criminal records spent convictions law in 2016. It's the last act which I wrote as a consultant before I got blacklisted. But anyway, so I wrote that, and of course I worked with the Ministry of Family Services and the department and so on. This is after I had left government, soon after I had left government. And we wrote that, and I remember that when it went to Parliament, just before, something like before a nomination day,
caller, I'm going to
in an amendment.
I'm going to ask you to just stick a pin 1 minute. I'm having the member for Georgetown Central trying to add in on this call. Let me see if I can add him. Okay. Just give me 1 second.
I could, if you can't add him, I can get off, and then we can begin later. Just feel free to do that.
Let me try, because I think he actually wants to join in on the conversation. 1 second.
Oh, okay, very well.
Good evening.
Evening, Sabrina. Malika, how you doing?
How are you?
We did
How are you today?
We did it. We did it
We did it for the first time. Oh, Sabrina, you are now really in charge.
Let me tell you. Welcome, member for Georgetown Central. This is a three-way call with yourself and Mr. Balika. What's on your mind? You're live.
Thank you so much. It's always good to be the first of something.
Oh yeah, we created history again today.
Interesting that you've been, like you said, down the rabbit hole about a lot of things, and all of them are so relevant. I just thought I'd put in some viewpoints and clarifications and additions, particularly in the last one. I think you said about the only thing that can bar you from running for office. Is murder. Actually, it's anything over the sentence of 12 months or more.
Okay.
No matter what the crime is.
Gotcha.
Once you serve 12 months or more. I had to know that intimately, because I got myself in a few
Thank you for the clarification.
With the law as a young man.
That's true.
So I know it intimately. But some things, regardless of the penalty that you get, you automatically are disbarred. So theft, dishonesty, political interference, things that are politically focused will bar you from running for office. So you can get 6 months, which doesn't meet the normal 12 months or over, but because of the nature of what it is. You can get a crime, a severe crime, but a lot less time. If you get 9 months in prison, you can still run for office. So I thought I'd clarify that. The other part about the district councils, that I think said that they were paid for positions. I've obviously been looking at this very closely, because I have a motion before Parliament about it, and I don't think the law specifies. And Malika, you can clarify for me, but I don't remember seeing it saying that they're paid positions. They could be like
allowances,
like a stipend.
Allowances like boards.
Okay.
Like a stipend, yeah.
Okay.
And you made another reference about the constitutional amendments. And there may need to be some, and there may not need to be some, depending on the government of the day, because I think the discrepancy is the word district, because the law and the Constitution didn't specify district as electoral districts.
Gotcha.
It's inferred that it's electoral districts, which would mean constituencies. But when the Constitution and the law were both implemented, obviously the Constitution first and then the law after, both were dealing with multi-member district electoral systems.
At the time.
And then we moved, exactly. So the law wouldn't have specified electoral districts. But there has been interpretations by some quarters, and this is where the problem lies, is depends on which government of the day interprets it the way they want to interpret it. So one government can say, no, it says district, so that means for Georgetown, West Bay, Northside, East End, and another government will come in and say, well, it's inferred as electoral district, therefore should be constituency, which is 19.
So clarification is imperative. Clarification, so yeah.
Yeah, so that's why in my motion, I suggest that whatever the government of the day intends it to be, or we have to have an agreement by all sides as to what the interpretation of the Constitution says. And there has been conversations that I've done some research on, that like Jeffrey Giles have said that it had to be inferred that it would be electoral districts, because the intention was to go to a constituency over time. But, you know, naturally, some people can disagree with that and say, no, it has to be specified. So, but ultimately, my motion is about whichever one it is, that it will be, whether it's district level or constituency level. I think the most important thing is that the people want to have an involvement in the decision making and the priorities of what the government will do.
Correct.
By these advisory reports. So I just thought I'd add that, and I'm actually loving the conversation. I would love to stay involved, but I would love to hear
more
viewpoint on that.
Okay, thank you so much.
Well, thank you, sir.
You can stay on.
To go back to the last, just the last point that we talked about the allowances. Section 363 says, 63 of the District Councils Act, it says, members who are not public officers as defined in the Constitution shall be paid such allowances as the governor and cabinet may determine. So you are right, Minister. To me, you're still Minister.
See, I know I wasn't so far off, KB. Sorry, Member George. See, he found it.
Yeah,
he found it. He found it.
They are not salaries, but they are allowances. They are paid in that
correct.
sense.
Yeah, correct.
They are paid in the sense that they are allowances. But I think, I don't know, probably, well, it was good that we clarified it. They are truly paid. So you were right, Sabrina, in the sense that they are paid. But we just needed to clarify that they are not like paid in the sense of salary.
Correct. So, but they're,
and which is a common provision, as you know, for any of these councils. So, Minister Brian, what do you think are the chances that your motion is going to pass?
Well, from a perspective of politicalness, if I can dare say that, I don't see any member of government or any member of parliament, period, wanting to vote against such a thing. Because you're basically saying that you don't think the people should have their say. If they try to refute it, it'll be on technicalities and saying, oh, we're trying to do it already and all of that stuff. But I think what we need to clarify, I think everybody wants it. I'd be honest with you. I think it's just
it was all campaigned for.
Exactly. And when we're going to get there. And I think that the urgency of the matter is the government has also committed to an appointment of a new electoral boundary commission, which will have to address the alignment of, the ratios of our numbers in each constituency. And the best timing to do that is to do it simultaneously while that conversation is going on. Make sure let's rectify this thing because they're interlinked, right? So if you're going to focus on a district level, well, are you going to add one more seat to Georgetown or to Bordentown? And what does that mean by the numbers of the makeup of who's on the council? If it's just going to be single member constituencies, advisory councils, then it wouldn't matter because you just do a group of people for every constituency. So it's good to hear where everybody's at because a lot of people think it's going to be more bureaucracy. I don't think so. I think because it is advisory, there's nothing wrong with giving your MPs the viewpoint of the community, and it's for them as the elected arm to take the suggestions or not, and they'll be held accountable to it if they don't, or if they don't give good reasons as to why they didn't, or if they do, go along with it. I think it's necessary. People are worried politically, and this is the problem, because I recognize my own feelings where I go, what if somebody on the council and wants to run against me? And I have to block that emotion.
It's a risk. It's a reality. It's a reality.
No. And I have to force myself to say, Kenneth, in your thinking, forget about that. It's not about you. It's about your democracy and the systems that you have.
Yeah.
So, and I think because of those emotional probabilities is why sometimes this has not been done. The politicians are getting in the way of the politics, right? So, but I do know this, one mandate that is clear that I can see over the last election is that they want electoral advisory district council. So just get it done regardless. I mean, we talk about that like, we did the immigration thing. We're not going to complain that people want this. But so do they want their say
district
in the electoral process by advisory and district councils. So let's get it done and stop worrying about selfishness. If somebody's going to run against me, so be it. That's democracy. That's what is necessary and healthy. So,
and you see, I think your motion. So sorry to cut you. I think your motion will be an opportunity to discuss a number of related issues to the motion as well. Because if, for example, people feel that the current law in the district councils act is not really the best, then those can be changed. Those are not in the Constitution. Those can be changed. And I think your motion is likely to highlight what the dissatisfactions are and give an opportunity for people to say, yes, we like it, or we like it, but we would like this and that to change. I think it will probably be the closest that we have come up to this point to enacting this, by bringing it to the House.
Yeah, and that's the most important thing. There was one more element about it that was of conversation, and I'm hoping it doesn't come back up again, because based on the notes of the constitutional discussions that Cayman had with the UK in 2008 and 2009, this topic came up and it was clarified, and I can give the notes to those constitutional discussions because I'm going to be using that in my debate. But the topic was about whether they should be elected or appointed. And I don't know how that continues to come up in the discussion, because it was clear when the negotiations were going on, Sir Alan McLaughlin and the Honorable McKeeva Bush, former premiers, both talked about it and agreed at that time, being government side and opposition side, that this is not election. This is simply advisory. So people are still bringing it up, and what it tells me is that was never a consideration about it being the intention at that time. So you can go back to the notes of the discussion when they were building the Constitution back then. But some people like to throw things in the mix to make it more complicated. I think that we're trying to perfect something rather than just starting something and make amendments as we go along.
I wasn't involved in the constitutional discussions. I was working for government then. But what I can say is that when we were writing this legislation, I remember that what you are saying is also what Mr. McKeeva Bush said, like in one meeting we had, that's what I remember from his mouth, together with the other people, OC and Dr. Steve. So, look, it's just a question of, at the end of the day, I think this is a good idea. It needs to be implemented with tweaking or without tweaking. It needs to be implemented. Nothing can ever be bad which encourages members of parliament to be able to communicate with their people. I know that of all people who've been in government and otherwise, I will embarrass you, Mr. Brian. You have been the best in terms of, I think, communicating with your people, structure or no structure. Okay, to be able to communicate with your people. Seriously.
Because I talk so much. That's why.
You are being unkind to yourself, but that's good. But it helps even a person such as yourself. I'm quite sure would be helped as well to even do even better with a structure of some kind. So
true.
Yeah. Well, funny you say that, because my good honorable friend, the former honorable minister Sabrina Turner, and I were speaking just last week about formulating a proper communication plan to the people on such a platform like this one with her. And I hope that we will be able to announce something maybe within a couple of weeks or so. But if I can, I want to go back to something the former minister said about, the type of government makeup and stuff. And I tuned in a little bit late because I was dropping my daughters to dance and basketball after school. I'm doing daddy work a lot more now than I used to. And it was to do with what I believe one of the main reasons why I joined the Progressives, because a lot of people recognize that as an independent, I was strong in my own right in my constituency. And a lot of people are like, Kenneth, you should have stayed independent. But I do believe now in the structural component, even though sometimes your independent thinking gets clogged in the whole party structure. But exactly what I was worried about happening is happening again. And I think, Sabrina, you talked about it, which is when you have, and I say this loosely with a small I, the ideological differences of groupings coming together. Like in my sense, this may sound crazy and somebody probably going to hold me accountable for it, but in my mind, I'd rather have a full TCCP government or a full National Party government or a full PPM government or a full independent government. But having different groupings where that there is things that ideologically clash on, it's bound to have similar problems like what we had as a part group, and hence the reason why I decided to say, okay, I may have had my differences with the progressives, but I know I can depend on the structure that's within their historical nature of their party. And I believe I can make some changes in that. But I think what we're whispering, I think you guys were talking a little bit about some whisperings going on, because now again we're starting to hear similar things on the Mall Road, if I dare say, about the government and problems they're having, because you're forcing square pegs to a round hole, or a round hole to a square peg, however they say that, because of the ideological differences. And we know that there's some differences between the National Party, the TCP, the PPM, and even some of the independents. I would love your thoughts on that, Balika, because it's something from a political maturity perspective that we have to start acknowledging before the next election.
I think he's picking up on the line, Mr. Balika, before you explain, on the line that we were talking, that you had said MPs need to have the right to educate the people. And I asked you, how is that supposed to be done? Remember, there was at the beginning when we were talking about the laws, you says it is MPs should be the ones educating the public about how laws work and yada, yada, yada. So go ahead. I think that's what he heard. Yeah.
I think that you can't argue against the need for coherence in any government. It's all very well to say, well, we formed the government in 4 days and so on. Well, if you form the government in 4 days, then in another 4 days, this one is pulling that way because you differ on the fundamentals. That is a problem. And I think you've got really a lot of authority, MP Brian, to speak about this because you have experienced it. Okay, you have experienced it. To me, the party system has to be something that has to be worked at. Yes, sometimes parties can splinter and all that and so on. But look, if you are going to form a government, you should have the majority of the people in that government should be of the same idea, and there should be a feeling that I belong to this group. Because sometimes it's not, you see, what matters is not just that you are of the same mind, but even the mere fact that you are in that group. There is a way in which you will not disagree unless you really need to, because you are disagreeing with people in your own group. Okay.
Exactly.
Yeah. So I really think you have gone through the experience. You have expressed it to me. I think it seems to make a lot of sense. I mean, the pact government, I mean, it's good that you say it, because towards the end, people were saying, well, Kenneth is talking too much. Why is he this and that? No, but it's because Kenneth was trying to represent his people. Some other people said, oh, Chris Saunders is talking too much, or he has to go. It is because it was a bunch of independents, and it was always a problem. Even if you agree, but if you don't feel that your future, your political future, at least in the immediate term, is bound together with the others, there is a way in which you will behave differently. And that difference is such that you will not be so willing to accept, for example, other views, to act with some forbearance in order for the government to continue in a coherent way. So I agree with that.
Well, if I can add something to reflect on, so we can consider. Yeah. So we've had what we call coalitions for the last 2 terms now, this one and the last one. And before that, we had one as well, which was the progressives. But there's an interesting label that they put on it, and it forced me to analyze it more and the behaviors of the leaders and the coalition of the group. It said it was a PPM-led coalition. Now, that just the PPM-led component specifies something. What it does is say that the PPM is the leading group within the bigger coalition, and they had a large majority. So I think back then they had 8, and it was like 3 other independents. So you had a group of 8 members who, at the very least, like you said, even if they disagree, they don't disagree so much because they're in a team together. So the stronghold was more so on the PPM side, though they needed, another 3 or 4 people to support and keep the government together. And even back then, it was difficult, even having a very large majority, because you will have independents who will disagree. And I'm not against independence. I want to make sure that is clear to everybody, because I believe in the independent principles of your own independent thinking. But that doesn't mean you can't work in a structured way. Now, the issue that I have is there's a level of sympathy that I have for the Honorable Premier Audrey Ebanks, because he doesn't even have a majority within the majority. He has 4 members. The National Party has 4 members, and then you have 3 independents. So if our human behavior characteristics were to be examined, like you just said, well, boy, if I disagree, how I disagree with my colleague that I went to war with in a campaign may be different than how I disagree with somebody who I joined with afterwards, or who may have different ideological viewpoints of me. So it's like a family member. Like, I'll be patient with my brother or my sister or my mom or my uncle when they're saying something I don't agree with, but I won't be as patient with a stranger. And I use that as an example because they're similar in the sense of the National Party probably would be patient with each other when they disagree, because everybody disagrees, no matter whether they're in a group or not. It's how you disagree and how you deal with it. Now, this pretense of, oh, we're all in kumbaya can only go for so long because of the ideological differences. And I'm going to use an example here. We know, everybody knows, that the TCP has a strong viewpoint on environmental components, naturally because of the Honorable former Premier Wayne Panton, who's a strong advocate for that. And then you have the opposite side of that, where you have some other members that are more stronger on the growth perspective, which comes to a conflict quite often. You see the recent article that is on CNS about a particular person who was on the CPA board, now on the National Conservation Council board, which are kind of like polar opposites. And this is where I get back to where I go, you know what? If I'm going to have a like just for an example of categorization, if I'm going to have a TCCB government, let it be a full, strong green team so that people can see exactly what that feels like in its totality. Or do I want a pro-growth and pro-success and building and more businesses and development? Let me see what that is. You know what I mean? Because at least in the, like, say, for example, in the United States, you have either you have a Republican government, whether you like it or not, they have certain characteristics. They're very strong on business. They're strong on immigration. Or if you have the Democrats who are more, pro civil life and social
a bit of socialism
policies, socialism in there. So at least you get, you know where you stand for 4 years. And this is the problem that I see is not only affecting us now, it's going to affect the leader of this country and his management, and it's going to affect the policy delivery, because even the board appointments, naturally people, I was appointing people who were similar in my ideological viewpoints on boards. And naturally, if somebody like Sabrina, she would appoint people who think like her. So when you have this mixed match of ideological management and authority from the various levels of ministries, the boards, to authorities, to ministers, to premiers, it's going to be complicated to cohesively run a country for 4 years on a certain direction. Because most times you're going to say, am I going left? Am I going right? Am I going up? Am I going down? Are we stopping? Are we moving forward? And that's where my analysis is. So I'll stop there. But Malik, I just want your impact, and Sabrina as well, what your thoughts are on that, because I think that's probably one of our biggest hurdles, regardless of what policy we take.
Well, I like what you said there. It's like, you see, you don't want, when you put a council together, you put people who disagree with you as minister and disagree among themselves. It's almost as if you put them in a ring to fight, Yeah. What you want to do is you want to put people like on a parade so that they can march together. I don't know if that analogy makes some sense.
Makes
because
sense to me.
It does, because even when you get elected on certain ideas, okay? You can't just say, well, let me get elected, because being elected is the most important thing. And then once I get elected, then we'll see what we're going to do. And it means you are not getting elected for the right reasons, because you should have certain policies, and those policies should work together with other people who will help you implement those policies. There will be always some disagreements, but by and large, people should share the same ideas and be able to pull together. That's the only way that you can be effective.
And I keep
That'd be my view on that. I agree.
And I like the numbers part that the member for Georgetown Central actually pointed out. Remember, the working arm of an administration rests in the decisions that come out of your cabinet. And based on the numbers and the analogy that the member from Georgetown Central pointed out, this is the composition of your cabinet. There are 8 cabinet members. Okay. You have the Premier and you have Minister Catherine Ebanks Wilkes. That's TCCP. Okay. 2. Then you have the independents. You have Mr. Isaac. You have Mr. Ralston. You have Jay. That's your 3. Then the other 3 cabinet members is the Deputy Premier. You have Nicholas DaCosta and you have Michael Miles. 3. So you have 3 independents, 3 CINP, and 2 TCCP. And of the 2 TCCP, 1 is the Premier. Georgetown representative, do you understand the numbers?
I totally understand, and I'm glad you elaborated further, but that's exactly my point. Even if the Premier for his TCCP group had a ideological principle, like say, for instance, the environment, does he have the strength to overcome
6 other members, because it's only 2 of his ideological standpoint represented in cabinet versus you're competing with 6 other persons that did not necessarily run with you, and it's 2 separate parties.
And if you look at this now, when you try to identify the ideological viewpoints on decisions, you have to go back to their manifesto and what they campaigned on. And I'm not going to go into the nitty-gritty of who campaigned for what. I think the public kind of has a good idea of what most people campaign for. But I can see where the clashes could easily become a problem for the government. Now, the Premier, rightfully so, will never ever say we're having problems with this, that, and the other thing, because that's not helpful. But I have to acknowledge all governments, all ministers, all premiers have struggles of
keeping
everybody together.
It's quite difficult.
But when it gets down to principal things that you foundationally agree with or disagree with, that's where the problems lie. So the little small minor things like, okay, whether the road should go left or should go right, or whether the minimum wage should be $9 as opposed to $8.75, those are, I don't want to downplay them, but they're not fundamental things like how I feel about same-sex marriages, how I feel about environment, how I feel about development, how do I feel about immigration. So you would find those things from an ideological perspective based on what they campaigned on and what they're committed to saying. And I'm already saying that I can see where the dilemmas will happen. Now, if I go back now to the progressives-led example, and I'm sorry for those who may not be too strong on the PPM, but let's say any government-led. Let's say it was a TCCP-led. If they had 8 and it was 3 independents, that 8 will have a stronger hold on the direction.
Of course.
Over the other 3. Right? So it's hard to navigate is all I'm saying. And I think it's bound to give us more and more headaches. That's all I'm trying to highlight.
So where do we go from here? Looking at the future outlook, you're looking at a motion. We're talking about future amendments to the Constitution. It's being asked, the participatory democracy and making sure that every person's voices matter through this channel. What do you see us looking like in the future as we continue to modernize and grow in this space? The mere fact we have shaken the space where people now feel comfortable in talking about situations like this, elected MP. And because before, publicly, you never had this level of discussion before, okay? This is not blowing my own horn. This is just factual. But where do you see us going in the future now that we have actually brought this in an open space and we're getting more participation being had?
Well, Sabrina, I can say this, that you are 100% right about the level of discussion and dialogue that we're having about this area due to your platform, because you're bringing something that a lot of other hosts couldn't bring, which is being there in the battlefield and knowing from experience what's going on, as well as your deep research into the various topics and your skill set as a host.
Mhm.
So you brought a new level to this. So let's admit that.
Thank you.
Now,
Yes,
in
that
respect
is
to
true. I agree.
answering your question, in respect to answering your question, I have to acknowledge my own bias. So I would naturally say to you, well, the future is going to be one of the People's Progressive Movement are going to get stronger. We're acknowledging our failures, where we have not followed the modern times, where the young people are, what's important to them,
Mhm.
and the progressives have failed to step up to the plate. And I am a part of that change, and that will come. That's just a selfish plug. But I'm thinking that the public, like you said, the public education has to understand what you're going to get when you have these different makeups. Because the truth is, with single member constituencies, you cannot control that you will have a full government of one thing or the other, whatever it may be, whether it's a Green Party, a pro-development party, a pro-immigration party. Because single member constituencies, every constituency have the right to choose who they want.
Mhm.
And that's what we chose from a constitutional perspective. So you may have a high probability of always having a coalition, and unless a strong group within one party is able to take the majority, and I say the majority meaning 10 at least, to control the narrative for a 4-year period.
And they must all get elected.
And they must all get elected. Now, the best way to handle this, like with any problem, is understanding the problem. So your expectations have to be realistic of what can be delivered when you understand there is going to be problems for deliverables because of these factors. And that's why I wanted to bring the conversation up, because I feel, listen, I may be selfish. I may say I want to be in government and my party should be the government. But I also feel bad for my colleagues on the government side, because I know the challenges they're going through, because I want them to win and succeed, because
We
when
need
they
them
succeed,
to. Yeah, we all succeed. Yes.
My country, my people succeed. Exactly. So yes, there's a bias, well, boy, I wish it was me, or I think that my solutions would be better, but I just want them to be able to progress. I don't want them to be stuck at one place. I'd rather you try something than nothing at all, if I can dare say that. But the differentiations between the ideological approaches can cause a lot of problem, and I think that we may find some fire very soon, because there's some unsettling things that affects the economy, the cost of living, the lack of growth or the progression of growth, jobs, immigration. All of these things are very sensitive topics. They're not just random things. Like, I'm not sure if there's a full position on things like immigration, like environment, like the development. And I don't see it clearly where I go, I know what I'm gonna see from this administration for the next 4 years on this topic. I can't tell it. And all three of us in this conversation are exposed to the political environment, and we're having trouble saying where are we going to be in 4 years with these various sensitive topics, because there's no clear definition of this group.
There we go.
Yeah, and those four that you've mentioned, those are like really core things. For example, you can't really govern coherently together if one or more of those four things, like you've got fundamental differences. You can't. I mean, if you differ, for example, fundamentally on what to do about immigration and job preferences, the government is going to crack sooner or later. So, but these are the efforts that should continue to be made. I mean, I'm so impressed with the way a lot of people are thinking about, the prospective amendments to the Constitution, looking at you've been looking at the Boundaries Commission and what happened about that. People are looking at the single member constituencies where this thing has worked, whether or not it has worked. It was very interesting during the last debate. It's like the moderator would ask, Mr. So-and-so, in Georgetown East, what are the problems? Even that sounded odd, because Georgetown East is not fundamentally different from the other parts of Georgetown or for the whole Cayman Islands.
Correct.
It's not like you are in Los Angeles and then you are saying, in East Los Angeles, what are the issues? That sounds like, yes, there might be issues in East Los Angeles which are different from West Los Angeles. So these are things which need to be looked at again. We'll see what happens. I think in the end, the public, but district councils can weigh in on some of these issues.
Correct. And I'm willing to actually look at that, the law that piece of legislation. But we are running out
Yes.
of time. It's almost 7.
Oh,
And yes, you see, when it's good, that's why you got called in early. I didn't even get to do the news headlines.
well, it is there. Well, it's such a great privilege,
Yes,
first of all,
yes.
to be able to participate with you,
Thank
Sabrina.
you.
Honorable Brian, you're always great, to talk to you,
Correct.
and always it helps me also to refine some of my ideas, from some of the way you view certain things. I thank you very
That's
much for
right.
this chance.
Thank you.
Well, thank you
Thank
so
you.
much, Sabrina. Thank you so much,
Thank you.
Malika, for allowing me to be a part of the conversation. There was one more question I wanted to ask. I know I'm not going to have time today, but I look forward to potentially doing this again because having more minds contribute to the conversation
Mhm.
and people listening to us analyze from different angles, they
Mhm.
learn together.
Correct.
There's another point that needs some administrative, some experience, some political, some current, some past viewpoints in it, because I would love your opinion. And if you're on tomorrow, Malika, I'd love to take 15 minutes with you and Sabrina to ask another question. But I'll leave it there by saying
Thank you.
so much, Sabrina and Malika, for allowing me on the show.
Appreciate it. Thank
Thank
you,
you, sir.
gentlemen. Have a good evening,
Bye-bye.
everybody. There we go. Of course, we're welcoming anybody. Once it gets, it's thought-provoking, it's respectful, we are willing to entertain it. But as we wrap up today's episode of Sabrina Speaks, I want to thank you all for participating. I'm, the wealth of information that we shared, Mr. Blika, I'm quite sure you'll be back tomorrow based on that. But I want to thank everybody for definitely being a part of the conversation today. All of the comments that are coming through, I want to thank you all for caring about our country and how it's even governed. And thank you for believing, as I do, in our country. And, until next time, I'm encouraging you all to stay informed, stay engaged, and definitely remain courageous. Keep on coming out, keep on participating. We can only grow stronger together. It has been my pleasure bringing you another episode of Sabrina Speaks. Until tomorrow, love you lots, be safe, and have a fantastic evening.
That's a wrap for today's edition of Sabrina Speaks. Thank you for tuning in and for being part of the conversation. Remember, the dialogue doesn't stop here. Stay engaged, stay informed, and most importantly, stay empowered. We'll be back tomorrow at 5 p.m., same time, same place, right here on CMR TV and radio, where your voice matters and your truth is heard. Until then, Cayman, take care of yourself and each other.
That's it for today's edition of Sabrina Speaks, where your voice matters, your story counts, and your truth is always welcome. Join us weekdays from 5 until 6:30 p.m. right here on CMR TV as we dive into the topics that matter most to you. Catch the show live or on demand at cmrtv.com. And don't forget to follow us on Facebook, YouTube, and Instagram so you never miss a moment. Until next time, stay informed, stay engaged, and always speak your truth.